You want to put that down? I need to talk to you for a minute.
Legal issues and the security officer, next on ProForce. Hi, and welcome to ProForce. Today I want to talk about the legal issues that affect the private security officer. What are the limitations, what are the rights, and how does the system work? Well, first off, let's talk about what is the law. What does the word mean? There is no universal definition for the word, the law. It describes many things. For security officer purposes, the law means the official rules which govern society. Now, the purpose of our legal system is to set down the obligations of one person to another and then to set penalties for violating these obligations. They also establish procedures for enforcing these obligations and assign penalties. Now, the legal system seeks to strike a balance between the rights of private persons and private organizations to protect their lives and property from outside interference and the rights of private citizens to be free from power or intrusions of others. For private security, the balance is between the protection of life and property versus the citizen's constitutional rights and freedoms. The security officer walks a very tightrope between permissible protective activities and unlawful interference with the rights of private citizens. Now, we have many sources for our authority and our limitations. Now, several of these sources help to identify the legal authority, the rights, and especially our limitations. The first of these, and perhaps the greatest, is the U.S. Constitution. The Constitution places limitations on all government activity, especially the workers' activities in the law enforcement and other criminal justice fields. But it says little about the rights of private citizens in their relationships to other citizens. So constitutional rights relate to the government or state actions versus the people's rights. Yet the restrictions generally do not apply to the activities of private citizens or corporations, and could apply only to security officers when they act as agents for public law enforcement or act in concert with law enforcement officials. Also, if you may be obtaining evidence for law enforcement officials, you may be bound by the constitutional limitations. Also, if you are acting with deputized police powers or with limited police powers granted by a local or state licensing or regulatory body, you'll be held accountable to the constitutional limitations. Also, if you're an employee of a public authority, your actions will be controlled by the Constitution. Remember that private security actions are almost never classified as state actions, except in those exceptions we talked about a moment ago. Now, if you have deputized powers or you work under contract for a public authority, your supervisor will instruct you on the constitutionally based rights, authorities, and limitations you have. Now, the next root of our power comes from common law. Now, this originated in England centuries ago. In early times, people would go to their feudal lords to settle their disputes. Now, the lord was expected to be fair and consistent, and he would rely on local custom. Now, this led to a belief that all laws were common throughout the land, even though these laws were not written down. Now, in reality, this did not occur, and many disputes had to be settled by combat, so the lord would not have to make decisions. When courts finally were established in England, judges would meet to discuss their decisions and achieve some consistency. Now, this resulted in the development of what we know as the real common law. Later, it found its way into the United States and became part of our judicial system. Common law still provides authority for many things which are not set down in statutes and provides defenses, for instance. It also provides interpretations for statutes. Common law is constantly changing, and it adapts to the needs of a changing society. The next source of our power and limitations is criminal law. All societies have rules governing criminal behavior. Now, centuries ago, violations were settled by blood feuds and private vengeance. But in recent times, these rules have been written into codes. Societies define what the criminal behaviors are and then describe them in detail in criminal or penal codes. They also include punishments to these various crimes. Now, the criminal code is concerned with acts or omissions which are offenses against the community. A private citizen cannot prosecute another person for a criminal act. Only a prosecutor representing the people and the state can prosecute a person for a crime. Now, guilt must be proven beyond a reasonable doubt, and punishment is always on behalf of the state, never the victim. The definition of a crime is an intentional act or omission in violation of a specific criminal law punishable by the state in the name of the public and is sanctioned by and in a judicial proceeding. Now, criminal behavior can be divided into two categories: property offenders and person offenders. Now, property offenders commit crimes such as theft and burglary, and person offenders commit crimes that injure people or hurt them, such as rape, robbery, and murder. Laws can also be divided into two categories: misdemeanors, which are lesser crimes, which generally involve crimes such as petty theft and these type of things, and felonies, which are more serious offenses and are generally punishable by a term in a state prison. Now, once again, the differences in definitions of these crimes vary from state to state. The next type of restriction or control and limitations on our activity, as well as our rights, is known as case law. Early English judges met to review decisions in order to achieve consistency. Later, these decisions were reported in books. Judges began to read these books to see what precedents occurred in common kinds of cases. Case law is frequently called precedent or the doctrine of stare decisis. That is, the principle of case law is that the court will stand by previous decisions. Now, in application, the doctrine is very complex and depends on whether or not the court was in the same jurisdiction and whether the level of the courts were the same. Also, it's very important that the facts in the cases are similar. Now we come to the statutes themselves. Statutes are the laws passed by a legislative body. Now, Congress passes federal laws, while state legislatures pass state laws. Counties and municipalities pass local ordinances or laws. Now, these are always being changed, and they're very dynamic in their very nature. Federal laws generally take precedent over all state laws, which in turn take precedence over local laws. And now we come to civil law. This is also known as tort law. Now, civil law describes a civil wrong. Now, this is found in legislative and court-developed common law. But there is no one body of tort or civil law, and they vary greatly from state to state. Now, the definition is that this is a body of law that governs civil relationships between people. It defines and creates causes of actions. That is, it permits one person to take action against another to remedy wrongs, to restrain conduct, and in the case of private parties, to seek relief from one another. Now, tort law protects us in many ways. It protects a person and property from injurious conduct. It protects a reputation from being harmed. It protects the privacy from unreasonable exposure and the mental well-being from emotional distress. Tort law covers conduct which harms another person. That is, when the conduct is unreasonable and without privilege or immunity. And also, this law does not provide specific authority for private security people, but does define some limits on conduct of security officers. A security officer can be sued if they damage or injure others when acting unreasonably or illegally. It also restrains the authority of security personnel only by threat of a lawsuit. And finally, it helps to define general rules of reasonable conduct through case law precedents. Now, a security officer has the same status as a private citizen in tort law and can be held liable in three different ways. The first is with the intent to cause harm. The second is through negligence. And the third is liability without intent or negligence. Now, intent will often come into play when you're talking about self-defense, especially in the protection of a person or the protection of property. Now, let's take an example when intent may be seriously involved in civil liability. When you're on patrol in your area and you come across someone in the act of committing a theft, you may attempt to take them into custody.
You gonna put that down? I need to talk to you for a minute.
At this time, they may attack you, and you will intend to use force to defend yourself. Now, later, the court will decide whether your intentional force was appropriate to the level of threat that you faced. In other words, if you were forced to fight the person and take the person into custody through the use of force, you're going to have intended to use physical force against that person. The court will ask itself, was that appropriate, and was it reasonable relative to the threat that you faced? Negligence will come in when the failure to establish probable cause, for instance, is involved in an arrest or in a detention. Now, civil liability has been increasing dramatically in recent years. The business community has seen damages skyrocket. Premiums have increased dramatically, and the security officer plays a role, a dynamic role, in protecting businesses against civil liability. The next is contract law. Now, this is the law covering binding agreements between two parties. Now, there are many types of contracts. For instance, a contract between a business enterprise and a security service, or a contract between the security officer and the employing organization. Now, contracts cover if there's any harm, who will be responsible. Union contracts sometimes spell out restraints on employers. An example might be whether or not they may search employee lockers, or in investigations regarding employee wrongdoings, whether or not they may use a polygraph. An example might be where you're investigating a criminal act and attempting to locate missing evidence or other property. While the contract may specifically give you the right to search many areas of the employee's workplace, it may in fact protect the employee's locker area, not permitting you certain access to parts of the locker. On the other hand, union contracts may give security officers very broad search powers. They may be able to not only search a locker, but all the areas of an employee workspace. The next type of laws we wish to deal with are regulatory laws. Now, these are statutes or rules and regulations as well as ordinances governing security businesses. These rules are found in licensing and registration statutes, and there are currently 75% of the states that regulate some aspect of the private security industry. Also, many cities and county governments require security businesses and security personnel to be properly licensed. Now, these often establish requirements and qualifications for security personnel, in most states allowing license revocations. The majority of states limit authority on the security officer. So far today we've talked about constitutional law. Those are the laws that define the rights of the government versus the rights of the people. Common law, which more or less defines for a court how to understand and define laws as they're written. Criminal law, which establishes behavior between individuals. Case law, which interprets laws by the cases as determined by judges. In other words, establishes precedent. Tort law, or civil law, which defines and creates causes of actions that permits one person to take an action against another to remedy wrongs or restrain conduct. Contract law, which defines the laws governing or binding agreements between two parties. And regulatory laws, which are the statutes, rules, and regulations which govern private businesses and professions, especially the security business. The specific section of the U.S. Constitution that relates to the rights of the individual is known as the Bill of Rights, and this is comprised of the first 10 amendments. Some of the key amendments are the First Amendment, which ensures our right to have freedom of speech as well as religion, and the freedom to peaceably assemble. The Second Amendment ensures us the right to bear arms. The Third Amendment ensures that we will never have to quarter soldiers in our homes except by our own permission. The Fourth Amendment protects citizens from unreasonable searches and seizures. Now, this is very important to a security officer who may be acting as a deputized officer or under the direction of a law enforcement officer. This amendment specifically requires you to obtain a search warrant prior to any searches, and that this warrant shall be issued only upon probable cause, and that the warrant will specifically list those items or persons to be searched and seized. The Fifth Amendment ensures that we shall not have double jeopardy. That is, we cannot be tried twice for the same crime, and that we will always have due process, or that is, a proper trial as well as a jury. The Sixth Amendment ensures that we will have a speedy prosecution, that is, the right to a fast and fair trial, and that you will have the right to confront any witnesses brought against you. The Seventh Amendment allows that in suits of common law where the value is greater than $20, the right to a trial by jury shall be protected, and that no fact tried by a jury shall be otherwise re-examined in any court of the United States, other than those rules accorded by in common law. The Eighth Amendment protects us against excessive bail or cruel and unusual punishment. The Ninth Amendment states that even though the rights mentioned in the Constitution are not great in number, that all other rights not mentioned shall still be protected and guaranteed to the people. The 10th Amendment states that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. Now let's deal with the types of criminal behavior that a security officer sees very often. The first is violent personal crime. Now this is generally an assaultive person. An example of this would be murder or rape, where someone actually is hurting or injuring someone else. The next type of crime is the occasional property crime. This is the periodic thief or person who damages property just spontaneously from time to time. These include shoplifters and vandals who may come onto your property or your business and cause damage or steal things. Next are occupational crimes. Now these are committed on the job. These include embezzlement or employee pilferage, where people will actually steal things spontaneously while they're on duty or working at a place of employment. Now we come to political crimes. Now this is where a person violates the law as an act of conscience. Now an example of this would be treason or espionage. In the late 60s and early 70s we saw this throughout our country. Now the next type of crime are public order crimes. This is where a person or persons disturbs the peace and quiet of society or a neighborhood or even another person. An example of these crimes are disorderly conduct or disturbing the peace, and even prostitution can be classified as this type of crime. Conventional crimes. Now these are typical everyday crimes. An example of these are robberies or burglaries that happen every day. You read about them every day in the paper. They're very, very common and a great problem that you have to face. The next is organized crimes. Now these are organized group activities such as commercialized vice or racketeering. The famous La Cosa Nostra is the most prominent example. But understand that any two people who get together to run a continuing criminal enterprise are in fact engaged in organized crime. Now we have professional crime. This is crime to earn a living. An example of this is confidence games or forgeries. This is where people are putting cons on people to gain a lot of money. Often you'll find them come into a business and run shell games at lunchtime or card games and try to make money by tricking people and getting their funds from them. Now we come to organizational policies. The employer generally is responsible for the acts of employees. Knowing organizational policy will help the security officer prevent injury or damage which could otherwise result in a legal action. Remember, security officers need good moral judgment as well as common sense and good understanding of the rules of ethical conduct. And remember, ultimately, we are responsible to protect the rights of others. Now let's discuss the most common crimes encountered by private security officers. These offenses are almost exclusively property crimes. First and the greatest is pilferage or employee theft. The next is vandalism, followed by burglary, check fraud, shoplifting, robbery, embezzlement, drug abuse, credit card fraud, receiving stolen property. Some of the typical problems encountered by security officers include carelessness. That is where an employee may fail to secure a door properly upon leaving. Or trespassing. Many times, kids, for instance, may come into a closed area and drink or commit other crimes or offenses and trespass upon a business property. Another typical problem is fire hazards. Very often, rags or boxes may be improperly placed, increasing the risk of fire or other threats. Vandalism. Vandalism comes in many forms. Often it can be juveniles simply painting or graffitiing the walls, as well as breaking windows or damaging business property. Disturbances, not only of employees, but often families and friends may show up and create disturbances on business property. Now the security officer's rights and limitations are generally the same as those of private citizens, and are generally different from those of public law enforcement personnel. They do have some common responsibilities, however, with law enforcement people. These include prevention, protection, investigation, responding to emergencies, reporting, detecting, and deterring crime. Now let's describe the criminal justice system. This system is composed of three basic units: The first of these is law enforcement. This includes officers from state, local, and federal agencies. Second is the court system. This includes judges, prosecutors, as well as defense attorneys. And finally, we talk about corrections. This includes jails and institutions, as well as probation and parole systems that vary greatly from state to state. Now, within the criminal justice system, there's two separate systems, one for adults and one for juveniles. Now, when someone commits an offense, they're going to be processed in the following manner. There's going to be 4 basic steps. The first of these will be the arrest. This happens after a crime and must be based upon probable cause. That is, that an officer must believe that a crime has been committed and that person who's being arrested has committed the crime. The second step is the indictment. This is where the formal charge is presented. A plea will be entered at this time and a trial date will be set. Next is a trial. Now, a person may be tried by a jury. Now, in felony cases, this is almost always a right, while misdemeanants have the right only in most serious offenses. Now, generally, a misdemeanant will be tried by a judge. All offenders are entitled to counsel. And this is always true in a felony case and also always true in more serious misdemeanors. Now, in a criminal trial, guilt must be proven beyond a reasonable doubt. Now, in a civil case, it was simply that of a preponderance of evidence. That is, 51% of the evidence had to say that a plaintiff was right or wrong. But in a criminal trial, it must be beyond reasonable doubt that a defendant is guilty. Now remember, in a trial, the defendant does not have to testify in a criminal case. Now, after a conviction, sentencing will occur. Now, this will only be after finding guilt in a criminal case. The term or length of a sentence will be determined by the criminal code. If guilty, a judge may impose a period of incarceration or a fine, as well as court costs and restitution fees. Probation is also an alternative, as well as splitting the sentence between incarceration and probation. Now remember that almost all offenders that are institutionalized are later released. 1, either by completing their term, or 2, as a result of a parole board action. Now if this occurs, then this condition requires supervision. Failure to follow the rules can result in this person being returned to prison. Now, in conclusion, we've determined that the scope of legal authority for private security officers is very limited. The scope is determined only indirectly as a result of various sources. Now, we've reviewed, described, and explored the significant sources. These have been the U.S. Constitution, common law, court decisions, legislation, administrative rulemaking, criminal law, tort law or civil law, and contract law. Security officers have no more rights and powers than those available to the private citizen. And we've also reviewed the criminal justice system and found that it's composed of law enforcement, courts, and corrections. We've examined the process the offenders go through, starting with an arrest, an indictment, a trial, sentencing, and finally release from prison if incarcerated. Well, as you can see, the legal issues are very, very complicated that affect the private security industry. Now, we've talked about the histories and we've talked about some of the sources of your power. But next week, we're going to talk about the specific effect of arrest and detention and how you play a key role in keeping liability to a minimum.